There's so much misinformation out there about that federal case involving the California National Guard. Did Gavin Newsom win? Is he now back in control of the National Guard? Did Donald Trump win? Is he now back in control? Short time, long term? What happened at the Ninth Circuit Court of Appeals? Why does that stay that they issued to block the trial judge not block him from doing anything else in the case? Why is the judge holding a hearing this week on the preliminary injunction, which could rock Donald Trump's world again and take him out of command? What is happening? I know, and my hand's up. Follow us on Legal AF because we just unpacked all that, blew it up, exploded it, did an explainer, put it back together again. Ben Meiselas and me on Legal AF, the top-rated podcast at the intersection of law and politics. Here's everything you need to know about the California lawsuit in federal court and on its way to the United States Supreme Court.
Let's get into it. Let's talk first about the case involving Trump federalizing the National Guard. The case is called Gavin Newsom versus Donald Trump in the Northern District of California. And the order that dropped on June 12th, 2025, so 2 days ago, granted the application by the state of California and the governor to block what Donald Trump did, which was to federalize the National Guard. The National Guard is normally under the control and command of the governor of the state. And Governor Gavin Newsom relies on the state National Guard in California to do things like wildfire prevention. You know, when there's wildfires in San Bernardino, for example, like is happening. That's how the National Guard is normally utilized. And when the federal government in an unprecedented fashion co-opts a state National Guard and sends 4,000 of the state National Guard to not really do anything of kind of clear purpose, just to make the showing of force and not know what they're even supposed to do. You're pulling the resources away from a state governor, states' rights. Isn't that what the Republicans always used to say? And you're parading them around for a show of dictatorial force in a way that's very harmful to the state. So Governor Newsom, along with the Attorney General of the state of California, sued the Trump regime and said, what the hell are you doing? This is unlawful. You're citing a statute, 10 U.S.C. 12406, which requires that you can only federalize the National Guard in very few circumstances. And there are 3 circumstances that are listed in the statute. 1, the United States or any of the commonwealths or possessions is invaded by a foreign nation. 2, there is a rebellion or danger of a rebellion against the authority of the government of the United States. Or 3, the president is unable with regular force to execute the laws of the United States. The statute 10 U.S.C. 12406 goes on to say that it is required that the governor basically agree to this federalizing of the National Guards at the request of the president to the governor, and the governor has to approve it. So the Trump regime, Michael Popok and legal AFers, they concede, okay, we haven't been invaded by a foreign nation, but they say we're under a rebellion against the United States right now, and that Donald Trump can't, with regular forces, execute the laws of the United States anymore. And so there was a hearing that took place this week, and Judge Breyer, the federal judge in the Northern District of California, looked at Trump's DOJ lawyer and says, come on, we're not under a rebellion. We're not under, you're telling me Trump can't execute the laws anymore because there have been 300 to 400 people who have been arrested in Los Angeles, which, by the way, it's like less than the amount of people that get arrested when the Dodgers win the World Series. Like this is not like I live in Los Angeles, like agitators and people who engage in any form of violence need to be dealt with the full force of the law. But by and large, almost all of the protests were peaceful. And then in terms of where the agitators were, a small area of downtown Los Angeles in a sprawling county, LAPD and LA sheriff saying, look, we're able to easily handle this. It didn't even get to the point where we would even think about the National Guard. It didn't even get to the highest levels of kind of the intra-department policies, because this is stuff that the LAPD and LA Sheriff's Department are just equipped to deal with. Popok, the Trump regime's, the DOJ lawyer, though, basically their main argument to the judge is you can't even ask us these questions. The moment that Donald Trump claims that there's a rebellion or claims that he can't execute the laws, it ends there because he's dealing with foreign policy. He's the commander in chief. The Constitution says that he shall take care that the laws are faithfully executed. So it's Donald Trump's subjective belief that there's a rebellion. This is not, and this is what this is the main argument that Trump made in front of the judge. This is not a justiciable issue. Courts have no roles in making this decision. This is purely the subjective intent of the president. And what was interesting, and I'll toss it back to you, Popok, is Judge Breyer cited some of the other cases involving Trump's deportations of people to El Salvador, and he cited a Trump appointed judge in Texas on the issue of justiciability. And let me just pull up this portion on justiciability because you can see how like one judge cites another judge, and it's interesting that he specifically picked the Trump appointed judge out in the Texas court. Judge Breyer says, this court agrees with Judge Rodriguez's thoughtful analysis in the JAV deportation case and finds it applicable here. To start, JAV is in line with other decisions rebuffing efforts from defendants to skirt judicial review of their alleged statutory violations. And so there's this whole body of law of the Trump regime saying we do whatever the hell we want. Courts, you can't decide. And there's courts saying, no, we do decide. We're the courts. Courts decide the law. And that's kind of where we're at, not just in this case, though, Popok, but in terms of like every case that Trump says, yes, that's what the law says, but the president takes care that the law is faithfully executed. Don't ask any further questions. That's it all comes down to that. So Talk to us. What did Judge Breyer do? Where are we at with the, Court of Appeals?
Well, there's been a development even since then. So Friday, we get the order. I'll read some aspects of the order that I find are the most interesting. As you said, Breyer finds, after a hearing in which he's very carefully questioning the lawyers for the Department of Justice, this is the family business. 83-year-old senior status judge in San Francisco, his brother Stephen Breyer of the Supreme Court. So he knows what he's doing. This is what I'm trying to, and he's seen it all. And he instantly goes to the statute that you talked about, which is known as the Militia Act of 1903. Basically says, I see the three things here. I don't really see how this is. He literally says in his order, I don't see how throwing mangoes, water bottles, and chairs, and maybe some concrete by some people, constitutes an armed rebellion, as that term is used in any dictionary definition from 1903 even till now. And how is it organized? These independent things. And he also said in the order and in the hearing, he's very troubled by the argument that it's your justiciable argument that Trump can declare any First Amendment expression where there are a couple of bad apples in there, a couple of bad actors in there, that doesn't convert First Amendment expression that is defended vigorously by our Constitution and our founding fathers into a rebellion to be quashed and crushed by a president. And that is a scary, slippery slope that the judge calls out. He has to start because, as you said, Trump always starts all of his cases with, it's political question, which is a bastardization of a political doctrine, a term of art coming out of the United States Supreme Court, that if it's truly a political issue, then the only way you can fix it is not in the courts, but at the ballot box. But this is not a political issue. Oh, yes, it is, the Trump administration says. It says here that I can have the power if there's a rebellion, I can't faithfully execute the laws, or an insurrection or other things. I get to use these powers, these superpowers, right? And I get to declare whether there is one of those three things under the Militia Act, and you can't challenge it because it's a political question. No, it's not. That is a misinterpretation on purpose of what the political question is in order to deny federal judges oversight. And every judge has to start with, Marbury versus Madison, which you and I learned like day one in constitutional law class in our respective law schools, all over again, Let's remind the president what the role of the federal judiciary is under Article 3 since the case of Marbury versus Madison. You do you, but we do us. And what we're doing us as judges, it's justiciable. So, and as you said, he points to Judge Rodriguez, a Trump-appointed judge in the Southern District of Texas, who ruled in one of the immigration cases against Donald Trump on Alien Enemies Act. And he says, I like that framework. I'm going to adopt that framework. But he also put Easter egg, bear trap. He also put in his order, in his temporary restraining order, a trap for the Trump administration, which they've already walked into. He said, I'm going to grant the temporary restraining order I'm going to find that what Donald Trump did was illegal, that it violated the Militia Act of 1903. This is that 10 USC 12406 statute we keep talking about, because none of the things that trigger your entitlement as president to use your power to commandeer, and federalize the state National Guard are present. And I get to oversee and provide oversight as to whether you're right or wrong. And so that's not present. So you have violated that. You also did not consult properly or go through the governor for the issuance of the order. They said, yes, we did. They said, how did you do that? Well, we typed the governor's name on the top of the memo. I said, sorry? You didn't consult with the governor. You barely spoke to the governor. You didn't coordinate any of these things that happened in the raids on the 6th of June. But we put his name at the top. Yeah, that's not what the federal statute and the act of Congress requires. The judge also found they violated the 10th Amendment, which is a little litigated, but very important part that holds our whole union together of federalism. It's if it's not in an act of Congress and it's not in the Constitution for a federal power, for a federal role, then all other power is in the hands of the people and the state. That's it. That's it. That keeps the feds out of a lot of different things and holds our union together, because states weren't going to join and leave the Confederation and join the United States of America unless they had continued state sovereignty and states' rights. And so Donald Trump has attacked that today it's California, tomorrow fill in the blank state, by coming in and violating the sovereignty of California. But the judge punted, but set up the trap on what we call the Posse Comitatus Act, which is an act that generally prevents anybody sitting in the office of the presidency from using the weight of the U.S. military, the awesome power of the U.S. military internally on domestic soil for law enforcement purposes. That sounds like a good thing. Like, I don't want the tanks and the M16s pointed at me by federal officers on domestic soil as a citizen or otherwise during a protest, because that violates the act. There are things you can do to support law enforcement, but you can't, for instance, detain people. And what Breyer said is, look, I got the record in front of me. I am issuing the temporary restraining order on the violation of the 10th Amendment and on the violation of the Militia Act. On the Posse Comitatus Act, we're close, but we're not there yet. But I'm setting a hearing for next week on preliminary injunction, because just to remind everybody, and maybe new people joining Legal AF, there's levels of injunctions and blocks that a judge, appellate, or trial can do. Starts with an administrative stay sometimes, which is like, it could be hours or days, just to give the judge time or the appellate court time to kind of get the briefs in. Then it moves to a temporary restraining order, which can last days, weeks, less than a month usually, maybe a little bit longer, until they can get around to the preliminary injunction. Generally, temporary restraining orders do not give appellate courts jurisdiction to review them and to stay them. Usually that you have to wait, as the Supreme Court has said recently, you have to wait till you get to the preliminary injunction phase. That's next week. The judge said, let's see what the evidence is, because I see a lot of speculation by California about the Marines arriving and what they're really going to do, but you don't have evidence yet that they have detained, arrested, and other things. But let's see what next week brings. And what do we have? We wake up last night, or we go to bed last night with the reporting of Reuters taking a photo of what appears to be a peaceful protester in zip ties, behind his back, by the Marines in front of the Wilshire Federal Building in LA, which is, and I'm sure there's more examples. So that goes like wildfire on social media and reporting that, okay, well, Breyer anticipated it. We now have the violation of the Posse Comitatus Act. Now, just to clear up where we are procedurally, there is a stay issued by effectively all three judges, but two Trump judges appointed in the Ninth Circuit on an emergency application for a stay of the judge's temporary restraining order. They've issued an administrative stay with a briefing schedule for next week to determine whether there should be a stay of the temporary restraining order while they litigate the underlying merits of the appeal. I don't see the grounds for it. I don't see them having jurisdiction for it. They've asked for a briefing from California, who I'm sure will say you don't have jurisdiction under the temporary restraining order. We're already in the process of preliminary injunction for next week. So stay out of it or keep your administrative stay, but don't make that other ruling. They are now briefing that issue, but that does not divest the trial court, Judge Breyer, of jurisdiction to continue administering justice in that case, including moving forward with everything else, whether it's a contempt proceeding in the future or the preliminary injunction hearing next week. That continues on a fast track. If he rules after that they have violated the 10th, the Militia Act, and the Posse Comitatus Act, he will enter a preliminary injunction, which now triggers appellate jurisdiction back to the Ninth Circuit. I assume that same panel. And then whoever is the loser there on it, as the time ticks by, because the troops are currently still federalized. I'm talking about the National Guard. And there's no ruling about the Marines yet. That will then go back to the Ninth Circuit, who will make whatever ruling they're going to make. And just because they're doing the briefing on a fast track doesn't mean they're going to rule on a fast track. You and I waited around 2 years ago for over a month for the immunity decision to come out of the DC court before it went to the Supremes. I don't know, could be another month, meaning troops on the ground, Donald Trump pouring kerosene over the fire in California in order to repress them and to suppress them. And so whoever loses at the Ninth Circuit in 2 weeks, 3 weeks, or 4 weeks, now we're off to another emergency application to the United States Supreme Court. And the question I have for you, Ben, is once it gets to the Supreme Court, given now what we know from the Trump law that's been developed over the last 175 days, watching them when it's presidential power versus immigration or due process rights versus church and state, all over federal funding and DOGE, all the rulings that we've gotten. Can you make heads or tails how when they're presented with this issue, this statute, this amendment, and this Posse Comitatus Act, what they're going to do? Welcome back. Or for your first time, maybe you wandered here. You wandered in here. Maybe the algorithm sent you here. Maybe you knew about Legal AF, the podcast. It's been around for 5 years, but I still feel like, we're sort of the new kids on the block, especially compared to mainstream media. Every Wednesday and Saturday at 8 p.m. Eastern Time, you can catch the live recording and the YouTube version only on the Midas Touch Network. Then we bring over clips over on Legal AF. Audio downloads, really important to the podcast. Even though we're the number one YouTube law and politics podcast, we could use a little help on people listening to us. That's the universal symbol for listening to us on the audio downloads. That helps with the algorithms. That helps tell people you like this kind of content. Legal AF, Wednesdays and Saturdays. Once again, I'm Michael Popok. Until my next report, I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. States and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.